Thank you, Madam Chair. That's precisely where I was going to start. This issue is not one of where the lease began. This issue is one of the president of the leasee, Mr. Trump, becoming president, and now in direct violation of the Emoluments Clause. So my question to you really deals, Administrator Murphy, could you please confirm for the record that the GSA has no idea whatsoever as to how much spending by foreign governments accounts for the income and profits at the Trump Hotel?
That's correct, sir.
So you have no idea about foreign expenditures at the hotel, correct?
The only thing I know is what I've read in the paper.
I'm sorry, the only thing
The
you
only
know
I know
is...
is what's been reported in the papers.
I see. Have you ever made an attempt to request information from the Trump Hotel organization regarding foreign spending at the hotel?
No, sir.
Why not?
Again, that would be the lease contracting officer's determination. And
I
it's
see.
not within
So
the
it's the
scope of the
contracting
contract.
officer. You were sworn in as an official of the U.S. government?
Yes,
And
sir.
you took an oath of office?
Yes, sir.
Did that oath include upholding the Constitution,
Yes, sir.
including Article 1,
Yes, sir.
Section 9, Paragraph 8, specifically the Emoluments Clause?
Yes, sir.
So that's included, but yet you've not asked any questions whatsoever from the Trump Hotel organization about foreign spending, which is an emolument.
The emoluments clause has been, issue is being currently litigated in 3 lawsuits I'm aware of. Those were filed before I became the administrator. I believe when there's a
And therefore, it's not your responsibility. Is that what you're saying?
I'm saying the Department of Justice has publicly argued that there is not an emoluments clause violation. They speak for the executive branch on issues of constitutionality. When there's a conflict, it's resolved in the courts. And when there's a final determination of the courts,
Thank you.
GSA will act accordingly.
We understand stonewalling very well around here. Let's see, it says, without the consent of Congress. It was earlier suggested that this committee has no interest. I would suggest that all of us read the Emoluments Clause, and it says, without the consent of Congress. Has Congress consented to foreign expenditures at the Trump Hotel?
Again, sir, it would be inappropriate for me to say
The answer is
more.
no, we have not. You're aware of that, I suppose. So you're basically saying that in direct contradiction to the Inspector General, you have no interest in determining whether there is foreign expenditure at the hotel?
The Inspector General has not recommended that we undertake any such action. The Inspector General gave us one recommendation, and that was that we prospectively alter the clause in the contract. And we've
Have you attempted to do that?
Yes, we have agreed to alter the clause, and we now actually use a reference to the underlying statutes instead, sir.
Have you, so you have no idea about foreign expenditures. You offered to the committee to show the records. Is that correct?
Yes.
As long as we keep it secret.
Yes, sir.
And you now tell us that those records have there's nothing in that record about foreign expenditures. That is who the guests are at the hotel?
No, those records, it's my understanding, would not include that information. Those records are, the financial records we receive from the tenant are those that are required by the lease. They include the audited financial statements. We receive that information. It does not give the level of specificity, though, that I believe you're asking about.
I would suggest that we need to get those records in order to determine if there are indeed foreign expenditures at the hotel, which of course we know there have been. With regard to the lease sale, I want a very specific answer. Are you going to investigate any potential sale of the lease as to whether it is from a foreign entity or a foreign government?
I'm not going to speculate on hypotheticals. I'm going to assess.
That is not a hypothetical. That is a specific question. Are you going to investigate whether the sale of the lease involves a foreign government or a foreign entity?
When we receive, if we receive an offer from the tenant to substitute a qualified transferee, we will do the assessment that is required.
So the answer to my question is no, you will not.
If that is required, that is what we will do. I don't know what the offer is going to be at this time. I don't know if we will
May I
receive an
suggest that
offer.
you carefully read the Constitution of the United States and your oath of office in which you said you would uphold the Constitution, including the Emoluments Clause. I yield back.